Who's the Expert? Frye and Daubert in Alabama. Written by Artyom M. Zhukov. 47 Cumberland Law Review, 275. Introduction. In 1923, the United States Court of Appeals for the District of Columbia decided Frye v. United States, establishing a general acceptance test for scientific expert testimony. This general acceptance test required the methodology used by the expert to reach his or her conclusions be generally accepted by the relevant scientific community. This test became widely adopted by many state courts, including those in Alabama. However, the adoption of the federal rules of evidence resulted in a reversal of Frye at the federal level, as is demonstrated in Daubert v. Merrill Dow Pharmaceuticals, Inc. In that case, the Supreme Court of the United States held that Federal Rule of Evidence 702 superseded Frye's general acceptance test. The court reasoned that the reliability and relevance principles implicit within the liberally construed federal rule resulted in the abolition of the Frye test in favor of a more flexible analysis by the presiding judge. Thus, the court anointed the judge as a gatekeeper, expanding his function into the field of weighing the validity of scientific methodology rather than simply relying on the consensus of the relevant scientific community. By doing so, the Daubert decision necessarily sparked the question of who is the real expert when it comes to the admissibility of scientific testimony. The scientist who says his methods suffice, or the judge who must second-guess the scientist and determine the sufficiency of the methodology for himself or herself. The court required trial judges to weigh the following factors, among any additional factors deemed important for consideration, when making their determination of whether particular expert testimony could be presented to the jury. 1. Whether the theory can and has been tested. 2. Whether it has been subject to peer review. 3. The known or expected rate of error. 4. Whether the theory or methodology employed is generally accepted in the relevant scientific community. The court's subsequent opinions in General Electric v. Joyner and Kumho-Tyer v. Carmichael supplemented the court's opinion in Daubert and now form the Daubert trilogy. In Kumho-Tyer, the United States Supreme Court not only reaffirmed Daubert, but expanded it to apply to technical experts, sometimes referred to as experiential experts, because their expertise spans from their wealth of experience gained by working in a particular field. In Joyner, the court ruled that the trial court's Daubert analysis is reviewed exclusively on an abuse of discretion standard, and in the same breath allowed the trial court to inquire into the sufficiency of the nexus between the expert's experiments, data, and analysis, and the expert's conclusions. In short, the Daubert trilogy has greatly expanded the judge's role in the evaluation of expert testimony, placing on the judge's shoulders the hefty responsibility of determining which scientific evidence is sufficiently relevant, reliable, and helpful to be introduced to the jury. The reversal of Frye at the federal level led to the adoption of the Daubert test by a majority of states, the retention of the Frye test in the minority of states, and general confusion in the state of Alabama. This article will lay out the history of Frye's general acceptance test in Alabama, the logic behind the modification of the test under certain circumstances prior to Daubert, and the general retention of the Frye test for 2 decades following Daubert, and the recent partial adoption of the Daubert test by the Alabama legislature and the Alabama Supreme Court. In Part 2, I will first give a brief summary of the historical overview regarding the presentation of expert evidence to Alabama juries. Then, I will dive deeper to describe the slow progression toward the Daubert standard capitalized by the partial adoption of that standard in recent years. In Part 3, I will describe some of the potential rationales for the sudden adoption of Daubert in most cases. I will also include some arguments that may still serve as the logical basis for a return to the Frye standard in Alabama, or in the alternative, a full adoption of Daubert in all Alabama litigation. Finally, in Part 4, I will discuss whether the recent adoption of the Daubert standard will also lead to the adoption of the Daubert trilogy, which includes the United States Supreme Court's elaboration on the meaning of Federal Rule of Evidence 702. I will attempt to demonstrate that adopting Daubert under the Alabama Rules of Evidence will necessarily lead to the adoption of the Daubert Trilogy in Alabama as well. Part 2. The history of the Alabama Expert Testimony Admissibility Standard. The general rule in Alabama courts and elsewhere is that witnesses should avoid giving their opinions on a particular matter, since the witness's testimony should put the jury in a position where the jurors can form their own opinions. Expert testimony is an exception to that general rule because an expert is supposed to possess education, training, or experience, which puts him or her in a better position than the member of the jury to form an accurate opinion regarding a particular set of facts. Historically, expert opinions could be offered only upon subjects that were deemed to be beyond the understanding of the average layman. However, in some situations, experts were permitted to testify on issues, even if the jury was competent to reach a conclusion on its own. Judge Colquitt articulates the logic of why such testimony may sometimes be permitted, so long as it is helpful to the jury. Merely because the fact finder may be competent to reach the correct result does not mean that he or she will do so. Historically, to determine whether a witness is in a better position than the members of the jury to draw a particular conclusion from the facts at hand, Alabama courts applied the general acceptance standard for most of the 20th century, although they did not always cite the Frye when doing so. The standard merely involved the determination that a particular scientific method was generally accepted or reasonably relied on by the scientific community. The judge usually did not have to wrestle with expert testimony himself, as second-guessing whether the expert's conclusions were sufficiently reliable due to the methodology employed was not yet necessary in the absence of Daubert. Furthermore, under the standard, before an expert could give his opinion, the proponent had to lay the foundation that the expert was qualified in the relevant field to give this sort of opinion. Qualifications of a witness involved having the witness testify about his formal education or training, if the witness was in fact formally educated or trained. Even if that was not the case, a witness could be qualified through a showing of extensive experience in the field. For court precedent and statutory language alike recognized that experience could be equally indicative of an expert's qualifications. It is this portion of Frye regarding the qualification of expert witnesses that survived Frye's eventual reversal both by federal and Alabama courts. In some ways, Frye's reversal at the federal level, and later to a lesser extent in Alabama, was always in the stars. The test struck a tentative balance between certain types of expert testimony. While the general acceptance standard articulated by Frye is easy enough to accept, the Frye standard actually came to require something more, that the method for gathering evidence used by the expert in a particular case was both novel and scientific. The problem with that view was that to be scientific under Frye, a method had to be well recognized. However, if it was well recognized, how could it be novel? The Frye requirement sought to strike a tentative balance between preventing well-educated people from testifying about common sense conclusions and preventing unsubstantiated scientific theories from being brought to bear by experts on the usually undereducated average juror. With the adoption of the federal rules, however, the United States Supreme Court saw an opportunity to get rid of this paradoxical balance, substituting another in its place. Alabama cautiously followed suit. After the United States Supreme Court issued its ruling in Daubert, Alabama gradually, but almost undetectably, moved towards the Daubert standard. This was true even though Daubert did not require compliance by Alabama. Since the decision rested on the United States Supreme Court's supervisory power and not on a constitutional ground which was incorporated to apply to the states, Alabama was free to adopt its own interpretation of state rules and regulations, even if the language of those state rules was identical to the federal rules. At first, Daubert only replaced Frye in DNA identification cases in Alabama. Thereafter, the Frye admissibility standard remained unchanged for more than 15 years. In 2012, however, Alabama adopted Daubert and applied it in all civil state court actions commenced on or after January 1st of 2012, and in felony non-juvenile criminal actions in which the defendant was arrested on the charge or charges that are the subject of the proceedings on or after January 1st, 2012. The change would not apply to domestic relations cases, child support cases, juvenile cases, or cases in the probate court. The effect of this most recent change will likely be felt for many years to come, because it represents a fundamental break with the historical application of the Frye test, rendering quite a bit of appellate court precedent inapplicable. The history of the Frye test in Alabama prior to Daubert. The Frye General Acceptance Test was not expressly adopted by the Supreme Court of Alabama until 1991. While the comments to Alabama Rules of Evidence Rule 702 formally mentioned the Frye test, the comments and the rules themselves did not exist for the vast majority of Alabama's legal history. However, a general acceptance test in some form was used within the state starting at least in 1953, when the Alabama Supreme Court mentioned the Frye test in dicta, apparently without adopting it in the holding. This general acceptance test was applicable to only scientific evidence and not technical evidence. It required general acceptance by the relevant scientific community of any scientific methodology, the results of which would be offered in court. In some situations, courts could accept evidence of this kind without proof of acceptance by the scientific community, where the acceptance was so well established that judicial notice could be taken of its widespread acceptance. For example, in Frye v. State, the Alabama Court of Criminal Appeals held that judicial notice could be taken of the fact that gathering and comparing DNA was a generally accepted method. Earlier in Johnson v. State, that court upheld the taking of judicial notice that fingerprinting was a generally accepted scientific method of identification. However, the general acceptance test had limitations. In 1980, the Alabama Supreme Court refused to apply a general acceptance test to testimony that involved forensic odontology, when the expert witness testified to the similarity of two skeletons. This led Alabama's lower courts to avoid directly applying Frye to other technical evidence, such as bite mark identification, blood spatter analysis, and field sobriety tests. A good example of a situation where the Frye test would not apply is the application of technical knowledge based on experience rather than scientific testing. The Alabama Court of Criminal Appeals previously held that a police officer's testimony regarding the flammability of a BIC lighter was not expert testimony subject to the Frye standard, because the testimony did not issue from the application of the scientific method or any experimental testing. Rather, the testimony came from the personal experience of the police officer, thereby rendering the expert an experiential witness whose testimony did not have to satisfy the general acceptance standard. Thus, when the relevant evidence came from the experience of an expert witness rather than from the application of a scientific methodology, the Frye standard did not need to be satisfied because it was inapplicable. In addition to refusing to apply the Frye test in certain cases, the Alabama Supreme Court made a pre-Daubert modification to the general acceptance standard under certain circumstances. In Ex parte Perry, the Alabama Supreme Court held that another prong should be added to the general acceptance test when DNA evidence is involved. The additional prong involved an evaluation by the trial court whether in this particular case the testing laboratory performed generally accepted scientific techniques without error in the performance or interpretation of the tests. This modified Frye test, which focused on the specifics of a given case rather than only with the general application of a scientific methodology, would come to be known as the Frye Plus test. Perry, however, did not affect the use of expert testimony in all cases that did not involve DNA, so the Frye test remained largely intact. After Daubert, initially, the Supreme Court's holding in Daubert did not greatly impact the use of the Frye test in Alabama. The holding in Daubert that abolished the Frye test in federal cases was based on the federal rules of evidence and the comments to those rules, which did not appear to recognize the Frye test. Since the federal rules of evidence did not apply in state trials, the Daubert decision was not binding in Alabama courts, giving Alabama courts the freedom to pick between Frye, Frye Plus, and Daubert. Alabama was at liberty to choose any of the three standards, or even to choose one standard for certain cases and another standard for other cases. The Supreme Court of Alabama faced several opportunities to adopt the Daubert test in a case holding, but each time resolved the cases without doing so. The court indicated that the door was open to adopting the test, but the justices did not walk through it. The Daubert test factors did eventually make it into Alabama law via statute, however. The state legislature, by passing a series of statutes, led Alabama courts to abandon the Frye Plus test in favor of the Daubert analysis in certain cases. In Turner v. State, the Supreme Court of Alabama overturned Perry, stating that the application of the Frye Plus test in that case was superseded by Section 36-18-30 of the Alabama Code. That statute provides, expert testimony or evidence relating to the use of genetic markers contained in or derived from DNA for identification purposes shall be admissible and accepted as evidence in all cases arising in all courts of the state, provided, however, the trial court shall be satisfied that the expert testimony or evidence meets the criteria for admissibility as set forth by the United States Supreme Court in Daubert et al. V. Merrill Dow Pharmaceuticals, Inc., decided on June 28, 1993. Accordingly, the court stated that this was an explicit adoption of the Daubert standard by the legislature in DNA cases, and therefore, Daubert analysis had to be applied instead of the Frye test. The Alabama Supreme Court also cited Section 36-18-20 to support its rulings regarding DNA evidence. In relevant part, the code states, Part D, the genetic identification technology through DNA testing is generally accepted by the relevant scientific community. Part E, that the procedures and techniques employing the underlying theory of DNA identification are capable of producing reliable results and are generally accepted in the relevant scientific community. Part F, that genetic identification established through DNA testing and analysis should be admissible as a matter of evidence in all courts of this state, and the juries, both civil and criminal, should be responsible for assessing the weight, if any, to be given to expert testimony or evidence. The court stated that the legislature found DNA testing to satisfy the Frye General Acceptance Standard, which in turn satisfied that prong of the Daubert standard, though other Daubert considerations applied. The ruling specifically avoided extending Daubert to other expert testimony, reaffirming Frye as the standard of admissibility in Alabama in all other cases. The Supreme Court of Alabama confirmed the application of the Daubert standard to DNA evidence, and the Frye standard to almost everything else in Bagley v. Mazda Motor Corporation. The court quoted Turner, as well as Cordell's Fibers, Inc. v. Long, in support of its ruling. The latter case was included to support the statement that this court has not abandoned the general acceptance test stated in Frye v. United States, and it has not adopted the Daubert standard in civil cases. The combination of Alabama Code Section 36-18-30 and the rule from Cordell's deserves some scrutiny. On one hand, Cordell seems to support applying only Frye in civil cases, even after the passage of Section 36-18-30. On the other hand, Turner in Section 36-18-30 seem to indicate that DNA evidence, whether offered in a criminal or civil case, should be evaluated under the Daubert standard. This discrepancy aside, however, the Frye-Daubert debate appeared to be settled until a relatively recent enactment by the state legislature. The legislature passed Alabama Act 2011-629, which amended Section 12-21-160B of the Alabama Code and became effective in 2012. That act stated in relevant Part A, generally, if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise. Part B, scientific evidence. In addition to requirements set forth in subsection A, expert testimony based on a scientific theory, principle, methodology, or procedure is only admissible if, subsection 1, the testimony is based on sufficient facts or data, subsection 2, the testimony is the product of reliable principles and methods, subsection 3, the witness has applied the principles and methods reliably to the facts of the case. The Alabama Supreme Court responded to this enactment with an order of its own, adopting the Daubert analysis of expert testimony in all cases, except domestic relations, child support, juvenile, or probate cases. An additional exception was included for criminal cases. In criminal actions, this act should only apply to non-juvenile felony proceedings, in which the defendant, that is the subject of the proceeding, was arrested on the charge that is the subject of the proceeding on or after January 1st, 2012. Though there has been no Alabama Supreme Court case to this effect, it appears that this recent Supreme Court order supersedes Turner, Cordles, and Bagley in proceedings that are not listed amongst the exceptions. So it may be correct to say that Alabama has become a Daubert state with a few notable reservations, although the authors and editors of the Trial Handbook of Alabama Law, for example, remain understandably hesitant to declare a winner between Frye and Daubert. Section 3. Potential reasons behind the recent adoption of the Daubert standard by the Alabama Supreme Court. Generally, state courts that adopted the Daubert standard have done so through two logical approaches: the comparative approach and the analytical approach. The comparative approach essentially relies on comparing the state's rules of evidence to the federal rules of evidence. If Rule 702 is substantially different in both sets of rules, then Daubert's reasoning logically applies to the state rules of evidence, thereby leading the state court to adopt Daubert. The analytical approach essentially involves analyzing the state's equivalent of Rule 702 itself and the legislative history associated with it, without any comparisons to the state rules language to the federal rule of evidence 702, to determine if Frye should be abandoned in favor of Daubert. As analyzed below, it seems that the Alabama Supreme Court adopted neither approach when largely adopting the Daubert test as of January 1st, 2012. Rather, it simply followed the statutory language enacted by the legislature, even though, in the realm of evidence, the Alabama Supreme Court has the power to amend the rules, even if the amendment is contrary to a legislative enactment. Subpart A. Did the Alabama Supreme Court implement the comparative approach to adopt Daubert? The order of the Alabama Supreme Court adopting the Daubert standard with respect to most expert testimony is relatively short, but perhaps some indication of the court's reasoning can be gleaned from it. The court stated, whereas this court wanted Rule 702, Alabama Rules of Evidence, testimony by expert, to be consistent with Section 12-21-160, it is therefore ordered that Rule 702, Alabama Rules of Evidence, be amended to read in accordance with Appendix A, attached to this order. Rather than stating that Rule 702 was sufficiently similar to Federal Rule of Evidence 702 for the adoption of the reasoning and holding in Daubert, the court stated that the rule, in its unamended form, was inconsistent with the amended Section 12-21-160 and had to be changed. Since the amended Section 12-21-160 was imposing the use of Daubert, that must mean the Alabama Rule of Evidence 702, prior to its amendment, was not sufficiently similar to the Federal Rule of Evidence 702 to apply Daubert to the majority of cases in Alabama. Therefore, it appears that the comparative approach did not lead to the court's holding. Did the court implement the analytical approach to adopt Daubert? This is subsection B. It is also unlikely that the court decided to adopt Daubert on analytical grounds. If Alabama's Rule 702 needed to be amended to be consistent with a statute imposing Daubert, it must mean that the pre-amendment language of the rule was insufficient to analytically arrive at the conclusion Daubert should apply in Alabama courtrooms. It seems plain that the amendment to Section 12-21-160 led the Alabama Supreme Court to adopt the Daubert approach. It is notable that the amended Alabama Rule of Evidence 702 includes within its language far more specific applications of the Daubert test than the Federal Rule of Evidence that led to the holding in Daubert ever did. Subpart C. Policy considerations behind the adoption of Daubert. It is likely that the court wished to be consistent with the state legislature when adopting Daubert's standard after the legislature amended Section 12-21-160. However, it is important to consider the strengths and weaknesses of the Daubert analysis when compared to the Frye test, as these may have influenced the legislature to pass the laws that made Daubert the appropriate test of expert testimony in most Alabama cases. I will begin with arguments in favor of the old standard, as the proponents of Frye tests may not yet abandon their cause in spite of the recent setback. Arguments in favor of retaining Frye. Although the Alabama Supreme Court and the state legislature seem to have left the Frye test behind in many cases, there are arguments in favor of its retention in legal proceedings that were exempted from modification by the amendment to Section 12-21-160. These same grounds can be used to advocate for a return to the Frye standard in all judicial proceedings within the state. The following list of arguments is hardly exhaustive, but the arguments appear to come in four flavors. Subpart A. Frye has been traditionally accepted in Alabama courts for almost a century, and stare decisis should lead the courts and legislature to retain a well-established and seemingly well-understood standard, which practitioners and judges in the state are used to. Elimination of the Frye standard also eliminates the useful precedent that serves as a guide for applying the test, leaving the judge unguided by appellate court rulings when it comes to the execution of his role. Subpart B. Frye properly defers to the scientific community to determine what is good science. Judges are neither used to making this determination, nor are they necessarily more qualified to do so. Even experienced judges may not know how to evaluate the validity of scientific evidence, despite seeing the evidence presented in their courtroom on several occasions. Seeing experts testify regarding a certain subject and obtaining an advanced degree in that subject are two different things, and a judge who has done the former may be far less knowledgeable than the community of people who have done the latter. Subpart C. Frye avoids placing the responsibility of evaluating scientific evidence on the judge, making the bench less active in including or excluding critical evidence that may swing the outcome of a trial. The gatekeeper role of Daubert is an uncomfortable one, for it places on the judge's shoulders the burden of admitting evidence they are ill-equipped to fully understand. Since trials can readily swing on the admission or exclusion of such evidence, Frye allows judges to leave the science to the scientists, instead of entering the field of scientific controversy unprepared and, in effect, blindfolded by a lack of scientific education and training. Subpart D. The Frye test appropriately prevents the examination of highly relevant, but also potentially highly prejudicial evidence by juries until a pool of experts is available to evaluate it in court. Subpart 2. Arguments in favor of the Daubert standard. There are also arguments to be made in favor of moving forward with the Daubert standard and applying it to all Alabama cases. As recent developments in state and federal law suggest, these arguments appear to have largely carried the day, at least when it comes to the Alabama and the United States Supreme Courts. Subpart 2. Arguments in favor of the Daubert standard. Oh, we've been there. Okay, Subpart A. The Frye standard may have allowed the scientific community to determine what is good science, but the scientific community is sometimes too slow to do so for parties to make use of novel discoveries and methods that may be critical to their trial strategy. Where stare decisis creates a result that is patently unfair, that precedent should be replaced if a better alternative exists. The Daubert test allows lawmakers to introduce into evidence scientific analyses that should rightfully be considered by the jury without waiting for scientific acceptance and scientific literature to blossom around the theory. In situations where undue delay may be a matter of convicting a dangerous criminal or obtaining relief for a plaintiff that cannot survive without expensive medical treatments that were necessitated by a liable defendant, Daubert provides opportunity where Frye provided disappointment. Although judges infrequently possess scientific training, they are well prepared to determine the impact certain evidence may have on a jury in the context of a trial. Some scientific evidence may not be very reliable, but it might influence the jury greatly. Daubert allows a judge to exclude such evidence, even though the scientific community may have accepted the inconsistent results of a certain method as something that cannot be helped. Daubert's anointing of the judge as the gatekeeper is nothing new when it comes to the admissibility of evidence. The judge serves that function in all situations where parties disagree regarding the fairness of exposing the jury to certain testimony. Nor is the application of a balancing test a novel concept. Rule 403 already imposes on the judge the duty to perform a balancing test when an objection arises on the ground that certain testimony is substantially more prejudicial than probative. Similar balancing tests can also be found in Rule 609. It is not consistent, therefore, for another balancing test to accompany Rule 702 if it will make the judicial process more fair. The judge is sometimes forced by the nature of the profession to make rulings he or she does not wish to make. If that does not prevent the judge from evaluating evidence offered by non-expert witnesses, that should not prevent him or her from evaluating evidence offered by experts. Subpart C. Although having a pool of experts available to analyze particular scientific testimony is preferable, it must be balanced against the potential necessity for the consideration of novel science. With the increased speed at which scientific methodologies and discoveries are reached in the 21st century, the Daubert standard is more in tune with the times by allowing those discoveries to be presented in a courtroom and permitting members of the jury to decide the outcome. The arguments in favor of the Frye standard may be persuasive to an extent, but it appears that Daubert considerations should bear greater weight. Tradition and stare decisis are important, but they can be modified by statute, as they have been, when the issue decided is not a constitutional question, and courts can choose to cast aside tradition and old rules when it appears that a better rule can be adopted. Although judges are not usually scientifically trained, they are probably less easily swayed than jurors by scientific evidence. Jurors, on some occasions, might trust such evidence almost without any doubt, regardless of the high error rate associated with some experts' methods, while a judge's discernment may prove far more skeptical. Judges' understanding of the impact of scientific evidence on the jury, that is also usually inexperienced in the relevant scientific field, trumps the understanding of other scientists on how a particular expert's applied methodology might persuade other experts. Because Daubert gives the judge flexibility, the judge may allow evidence from experts in the minority of the scientific field to be admissible, where it will aid justice and proper consideration of the issues by the jury. He or she might also allow novel scientific methodology that would otherwise be excluded under Frye, since Frye could technically exclude methodology that may be more likely to become widely accepted in the relevant scientific community within the coming years, or even months. In any case, the Alabama legislature believed it prudent to adopt Daubert with some exceptions, and the current trend might be towards doing away with Frye in Alabama altogether. Part 4. Unanswered questions. Daubert or Daubert trilogy. The legislative adoption of Daubert in a wide variety of cases still does not clearly define the standard in Alabama regarding admissibility of expert testimony. If the inclusion of one really means the exclusion of the alternate, as Marbury v. Madison suggests, then the legislative language behind the amended section 12-21-160 indicates that the legal proceedings to which Daubert is not applied via the amendment would still use the Frye or Frye plus test. However, the Alabama Supreme Court could have been much clearer regarding the adoption of the Daubert standard in the legal proceedings to which amended section 12-21-160 does apply. It is understandable that Daubert was adopted in whole, which should logically include its reasoning as well as its holding. However, does adoption of the case's reasoning lead also to the adoption of the reasoning and holdings in Joyner and Kumho-Tyre, which came after Daubert at the federal level? It appears that the Alabama Supreme Court, by ordering the inclusion of Daubert into Rule 702, may have also adopted the logical extensions of Daubert included in the Daubert trilogy. That the review of a trial court's admission of or exclusion of expert evidence shall be carried out on an abuse of discretion standard, that if conclusions are too separate from the methodology used to reach them, then they are inadmissible, and that the Daubert analysis applies to technical as well as scientific experts. It is fair to reason that if the legislative act essentially resulted in the application of Daubert to so many judicial proceedings in Alabama, the meaning of the language of both Daubert and Rule 702, as discussed in Joyner and Kumho-Tyre, might be adopted as well. The Supreme Court of Alabama may still have a small window to rule that some distinctions can be made, since the Alabama Rule of Evidence 702 is not the mirror image of the federal rule. The court may also adopt the argument that even if the rules were identical, it had the freedom to interpret the Alabama rule differently despite identical language. However, the adoption of Daubert by the court seems to equate the rules in terms of their effect, even without equating them textually. it may be argued that the court specifically chose to amend Alabama Rule of Evidence 702 with language differing from the federal rule to draw a distinction between the rules that would allow the holding of Daubert to be adopted without the adoption of Joyner and Kumho-Tyre. It may also be argued that the Alabama Supreme Court's statement to adopt, with some exceptions, the standard for scientific expert testimony established in Daubert v. Merrill Dow Pharmaceuticals, Inc., could allow the court to consider the Joyner and Kumho holdings as exceptions and thereby not adopt them. It is far more likely, though, that the word exceptions refers to the judicial proceedings to which the state legislature did not extend the amended Section 12-21-160. The Alabama Supreme Court has already adopted Daubert when it did not necessarily have to do so. The language in the amendment to Section 12-21-160 did not necessitate such interpretation, yet the court saw fit to conform Alabama's evidence standards to federal ones. If the reasoning which led to this result has not lost a great deal of momentum, the court will likely adopt the Daubert trilogy outright when the appropriate case gives the court that opportunity. This is particularly true of the holding in Joyner that the judge's determination under Rule 702 is to be reviewed under the abuse of discretion standard. After all, Daubert appears to expand the judge's discretion when it comes to determining the admissibility of expert evidence, and the review standard will likely be one accommodating of that discretion. Part 5. Conclusion. Alabama's long-lasting resistance to Daubert deserves notice. The state has been faithful to the Frye test when evaluating the admissibility of expert evidence for almost a century. However, recent developments that followed the amendment to Section 12-21-160 by the state legislature mark a serious turning point. With some notable exceptions, the Alabama Supreme Court and legislature are ebbing away at the Frye standard and adopting in its place not only Daubert, but likely its progeny as well.